an individual can be personally liable. So the victim of the harassment will naturally go to the employer, who will typically have deeper pockets. But if they're well advised, then they will also go after the manager or after the perpetrator.
Viewers, having a mental health and safety risk management system is not a nice to have. It's not a pretty add-on, to what you already have. It's actually mandated by current legislation. As
everyone has protected characteristics. Everyone has an age, for example. So if you're treated less favorably because you are young, or because you are old, or because you are middle-aged, you have a claim.
Hello, I'm Cesar, and I'm the founder and managing director of Dharma Center for Wellbeing, and I would like to welcome you to Re-Engaged at Work, a podcast designed with you in mind to help you improve retention, engagement, and performance through workplace well-being. Now, before we begin this episode, make sure to click on the subscribe button below so you can be the first to benefit from the knowledge, experience from all of our distinguished guests. And speaking of distinguished guests, on today's episode, we've got Mr. Andrew Brown, whom I've developed a really good relationship with. Andrew, would you like to say hi? You're muted, Andrew.
Okay, so that's my first mistake. So, yes, hi. Thank you very much for having me on the podcast. So my name's Andrew. I am a partner in the Employment, Immigration and Pensions team at Anderson Stathern Solicitors. So my job is to advise clients, both individuals and employer clients, on all aspects of employment law.
Fantastic, Andrew. And I understand also that you have a wealth of experience, obviously, in the general employment law field, and that you're a specialist expertise in the areas of industrial relations and HR support. I also understand that your client base is quite wide. You basically have served the UK government, higher education establishments, and SMEs as well. And a particular part of your experience that we're going to be talking about today as well is your experience in advising employees and representing them in settlement agreements and also in the Employment Tribunal as well. So that's really good experience that we'll talk about today, Andrew. And for those of you who do not know Andrew that well, he likes to socialize with family and friends, and on occasion, he's been to the gym. Right?
I was there this morning.
Oh, yeah, there we go. Fantastic. Andrew, thank you so much for taking the time to, to join our episode today. And, the topic of today, obviously, is helping employees know their rights and helping employers as well know their rights as well, when it comes to the legal duty of care. Now, it's interesting how when I go around the UK and ask leaders, whether they actually comply with their legal duty of care, I would say the majority of them are very hesitant to actually say yes because they don't really understand the scope of what that actually means. And some leaders actually do say to me, you know what, I didn't know that I actually had a legal duty of care. And then, of course, you have other leaders that say, yeah, of course, we comply with our legal duty of care because we bring fruit baskets and we, hire yoga teachers and we provide mindfulness training and resilience training. And we've got an EIP system and we've got mindfulness weeks and health fairs. So we do loads. So we comply with our legal duty of care. We're covered. Thank you so much. And some of them, I call these leaders the well-meaning leaders. They mean well, but they're not necessarily doing the things that will actually make them legally compliant or doing the things that will allow them to achieve national standards or international standards of workplace well-being. So the first question that I'd like to ask you then, Andrew, is what is the legal duty of care? What are the employer's responsibilities toward their people?
Of course, well, there's one overarching responsibility that employers have, and that's to broadly speaking, to take reasonable steps to prevent your employees from suffering harm. And harm can occur in all sorts of different ways. It's not just a case of checking your factory to make sure that people don't trip up or don't get hit by a forklift truck or something like that. Harm can happen in other ways, through excessive workload, through behaviours at work, whether it's bullying, harassment, all sorts of different ways in which harm can occur. And the employer has to take reasonable steps to prevent that harm from occurring.
Right. So when it comes to preventing harm, as you were saying, there are several categories of hazards. You've got the physical hazards, you've got the chemical hazards, the biological hazards, the ergonomic hazards. But there's one particular category of hazards that has been kind of ignored, which are the psychosocial hazards. Psychosocial hazards defined as factors relating to the way work is organized, designed, and managed, and social factors at work. And we will delve into psychosocial hazards in a moment, right? Why, from your opinion, right, why is it that employers have kind of ignored, this particular type of hazard, which actually can create, psychological harm, to use, technical terms? Why do you think that's been the case?
Okay, well, I mean, I think some employers are better than others in this sphere. I suppose it's probably been easier to tackle some of the physical things that you can see, and you can walk around the workplace and you can see the physical hazards. And I suppose until perhaps recently, most claims, or rather, probably still is the case that most claims are from physical harm. But there's an increasing number of claims that are being caused by psychological harm. And people are increasingly aware of their rights to pursue employers or even colleagues if they are subject to, as you call them, as you mentioned, psychosocial behaviours or psychosocial hazards. And so I suppose employers take some time to catch up and to start realizing, well, actually, hold on, this is the new emerging area of risk. This is now the risk that I need to start tackling. I might have all my health and safety policies in relation to physical hazards, but now I need to start thinking that this is the area of risk to be tackled.
All right. And obviously, again, we're going to go into the psychosocial hazards in a moment so that our listeners and viewers can actually understand generally what those actually look like, what those are. But it's good to remind as well our listeners and viewers, what are the pieces of legislation that actually support the need for employers to safeguard the welfare and the psychological welfare as well of their employees, right? So, and correct me if I'm wrong here, Andrew. So we've got the Health and Safety at Work Act from 1974. We've got the Management of Health and Safety at Work Regulations of 1999. And we've got the Equality Act of 2010, which we will actually talk about in length and later on. Are those the three main pieces of legislation? Is there another piece of legislation that basically guides employers to look after the psychological welfare of their employees as well?
Okay, well, the first thing I would say, all lawyers like to have a caveat in any of their advice. In anything that a lawyer says, there's always some sort of qualification to it. And here's mine. So my role and my expertise is as an employment lawyer. And that involves all aspects of employment law, but it doesn't involve personal injury claims. Now, by that, I mean claims that are brought in the civil courts. My area of practice is in the Employment Tribunal. So I wouldn't profess to be an expert on all personal injury matters. There are personal injury matters about which I know enough to to say to employers, you need to speak to one of my colleagues. And there are aspects of personal injury that relate specifically to the Equality Act 2010, which you mentioned, which I am, of course, very familiar with, that being my area of expertise. But there are lots and lots of pieces of legislation underpinning the obligations of employers, but all of them have somewhere within them this overarching responsibility to take reasonable steps to prevent harm, whether that's under health and safety legislation or it's under anti-discrimination legislation like the Equality Act.
Yeah, fantastic. So just to be clear for our listeners, from this point onwards, our focus will be primarily on psychosocial hazards. We're not going to deal with physical hazards or chemical hazards or biological hazards. It'll be primarily focused on psychosocial hazards. And again, as I was saying, psychosocial hazards are the factors around how work is organized, designed, and managed, and the social environment, at work that could lead to psychological harm, which could eventually lead to psychological injury. So, for instance, right, role expectations. I mean, within role expectations, you've got role ambiguity, conflicting demands, frequent changes to tasks. So those are typical psychosocial hazards relating to roles and expectations. So to make it practical, let's say that Andrew and I join XYZ business, on January 1st. And he's given his role and I'm given my role. And then we both realize that there are certain aspects of our role that conflict with each other, right? So when I'm trying to do my thing and Andrew's trying to do his thing, we tend to butt heads because that's the way, it's been a faulty design. So that's creating stress for Andrew. That's creating stress for me. Now, the typical approach, on an average business is, oh, Andrew, you're feeling stressed out about your work. Let's here you have some what do you call it, resilience training. Here's some stress management training for you. Here's a yoga class for you. Here's a meditation class for you. So they're not actually, they're basically treating the symptoms, but they're not actually addressing the root cause of the problem, which in this case is role conflict or role ambiguity, and those are considered psychosocial hazards. For other psychosocial hazards, as you've mentioned already, Andrew, workload, work pace, work hours, remote working or working in isolation, the social factors that could be considered psychosocial hazards as well are interpersonal relationships. Perhaps I might have a conflict with someone. Perhaps I believe that I have an unequal relationship with someone, or harassment, bullying, victimization. Those are social hazards of a psychosocial nature as well. Or perhaps, elements around leadership, lack of trust, inconsistent leadership, poor decision making. That's a psychosocial hazard, right? And there are factors around the work environment as well. Whether I'm getting the support, whether I'm getting the equipment that I need, and whether I'm getting the resources that I need in order to do my job. So there are literally dozens and dozens and dozens of hazards of a psychosocial nature, but I've just given our listeners a bit of a taste as to what those are, because those situations are primarily responsible for causing the work-related stress, work-related anxiety, and work-related depression. So unfortunately, because most of the health and safety professionals have been accustomed to just focusing on the physical hazards and the chemical hazards and the biological hazards, they might not be well versed in the dozens and dozens of psychosocial hazards, and it kind of limits their ability to be able to to help the companies that they've been helping helping for years in a very effective way on dealing with all those other types of hazards, right? Now that we've Andrew, so now that we've given a bit more clarity around, what a psychosocial hazard is, right? Can you give me an example of cases that have been brought forward to the Employment Tribunal that deal with a breach, in duty of care in relation to a psychosocial hazard that was not managed well?
Okay, yes, so actually I dealt with a case where I was acting for the employer, and one of the issues around the case was whether or not we had removed the responsibilities of an individual's role, whether we'd changed their role to a material degree. And now all roles evolve over time. People's responsibilities change over time. But if the responsibilities are changed suddenly or changed unfairly, then that could give rise to a situation where an individual says, I'm out of here. I no longer want to work in this business because of the way in which you've treated me. You have breached what's called the implied term of trust and confidence. You have breached my trust, and therefore this relationship is at an end. And an individual in that scenario can treat themselves as if they have been dismissed. That's what's called constructive dismissal, and it's a term that you'll have heard before, but it's quite often misused. What it means is an employer has treated an individual so badly that it's as if they have just walked up to them and dismissed them without reason. Well, and so I had a case where an individual did pursue that claim and said that my client had removed such a significant part of her role that it made her position untenable, and she left as a result of that. Now, as it happens, we were able to show that what had happened in that case was a natural and necessary evolution of her role, rather than something that was done to her. And so we successfully defended that claim. However, the result could have been very different if we hadn't been able to show that we had a good reason for these changes, and if those changes had been deemed to be material changes to somebody's role. And from time to time, you do get employers who do think that, well, they're paying the individual, they can just change the person's role, and it's not up to the individual what role they perform. They've still got the same job title, they've still got the same pay, they've still got the other terms and conditions, without recognising the significance to the individual and to the law of that individual being allowed to perform the tasks that they had anticipated that they'd be performing when they took on the job.
All right, so let's bring another example, right? So, and this is a concern that has been brought to me many times. I've spoken with employers that say, but wait a minute, listen, stress is part of life. You know, stress is an experience that's not uncommon when someone performs a specific duty or a specific responsibility. Does that mean that as soon as someone is experiencing a little stress that they're going to, take me to the Employment Tribunal? And so the question that I've got for you is, let's again, let's pick a psychosocial hazard, right? Bullying. Now, it's interesting. So first of all, before talking about bullying, you and I had a chat a while back about, the difference between harassment and bullying, and there's an official definition for harassment and not necessarily one for bullying. Can you please just, compare and contrast the two before we go on with this example?
Yeah, of course. So you get bullying, and bullying doesn't have a statutory definition. It doesn't. There's not a legal book that says here is the law. Here's what bullying is. It's Section X of X Act. But there is a body, a government-funded body called ACAS, and ACAS, their role is to provide, or one of their part of their role is to provide guidance to employers on the law and what their legal obligations are. And so they have a definition of bullying, and their definition of bullying is similar, well, very similar to the definition of harassment under the Equality Act. So I'll tell you what the definition of harassment under the Equality Act, and forgive me, I won't get the words exactly right because I didn't think to have it in front of me, but the definition of harassment is unwanted conduct that has the purpose or effect of violating an individual's dignity or creating a humiliating or offensive or intimidating environment for the individual. So, but in the context of harassment, that has to relate to a protected characteristic. It has to, and by protected characteristic, we mean sex, race, sexual orientation, religion or belief, age, marital status, these kind of things. These things that the law protects an individual, and you can't treat somebody badly because of a protected characteristic. You can't treat them badly because of their religion or belief, for example. Whereas bullying doesn't need to be tied to a protected characteristic. You can bully somebody because they are wearing a red jumper. You've decided that you don't like the colour red, and you're going to pick on them because they've got a red jumper. If it's unwanted conduct and it makes them feel offended and humiliated and things, then it's still bullying, but it's not harassment under the Equality Act. And the reason why that's significant is that if it's harassment under the Equality Act, then an individual can bring a claim, and it's a standalone, freestanding claim saying, I was offended. They don't need to leave the employment, they don't need to resign, they don't need to claim constructive dismissal like we spoke about earlier. They can just say, I was offended by the comment that was made. It can even just be a one-off comment. And the only way in which an employer can successfully defend a claim, if this comment occurred and if it was offensive and it was reasonable for them to be offended, is if the employer can show that it's taken reasonable steps to prevent that kind of behaviour. Now, coming back to the point that you made earlier, César, around the individuals that are suffering stress, and employers are thinking, well, stress is part of life, and get on with it, dry your eyes, which is sometimes the approach that some employers take, and to some extent, the courts and the tribunals accept that. They accept that stress is part of life. They accept that it's part of the workplace, and that's not necessarily always a bad thing, and it's not illegitimate. Individuals don't have a right to come to work and never feel stressed, but where it's more problematic is if that stress results in an individual suffering harm, and by that I mean material harm. And if an employer knows that a particular individual is vulnerable, so perhaps they know that an individual has suffered a stress reaction previously, perhaps they know that the individual's had a nervous breakdown, perhaps they know that the individual has an underlying health condition that makes them more vulnerable, then the employer has to behave differently and treat that individual differently than they would treat another person in order to level the playing field. And that's particularly, we see that in particular where an individual has an underlying health condition that might amount to a disability. If an individual is disabled in terms of the Equality Act 2010, then there is a duty on employers to make reasonable adjustments and that might involve adjusting the individual's role, adjusting the expectations that they have. So coming back to the point that you're making, César, around stress being part of work, yes, that's right. But where employers have to be particularly careful is if they know or they ought to know that that individual was in fact a bit more vulnerable than others.
Okay, and so just to be clear, right? For a claim to have a higher success rate from the employee standpoint, harassment needs to happen associated with a protected characteristic, which, as you mentioned, could be age, sex, sexual orientation, race, pregnancy, religion, etc., right? Okay, and the employee must actually have in the past. It's a vulnerable employee, meaning that this particular employee has had some kind of negative experience when triggering the stress response. So, what if those conditions are not present? What if the employee hasn't had any kind of bad reactions to a stressful situation in the past, but they've experienced harassment under any of those protected characteristics? Does the employee still have a chance to, for a successful claim?
Yes, sorry. Yes, I realise now that perhaps hadn't been clear enough. So when we're dealing with, if you were dealing with a bullying claim, so not a harassment claim under the Equality Act, but a claim for an individual says that they've been bullied, nothing to do with a protected characteristic, then that individual would have a couple of different ways in potentially pursuing a claim. One would involve resigning and saying that they've been treated so badly that they've been constructively dismissed and their employer has done nothing to help or has created this environment where they were treated in this way. The other is a personal injury claim in the civil courts. And that's where it's what's significant is what the employer knew about the individual's vulnerabilities. But coming back to tribunal claims for harassment related to a protected characteristic, then those claims don't need to come from individuals that have an underlying health condition. The obligation to make reasonable adjustments that I mentioned earlier, that applies if an individual is disabled under the Equality Act, if they have this underlying health condition. But let's imagine an individual that doesn't have an underlying health condition, but is still treated badly, and is treated badly only in that one-off occasion, and it is that banter, that comment that the individual, the perpetrator, if you like, intended it to be a joke, perhaps. If it relates to a protected characteristic, and if it offended the individual, and if it wasn't unreasonable for the individual to feel offended, then that individual has a claim. It's only, even though it's only happened once, even though they are not particularly vulnerable to these things, even though the employer might not have known that this was going to happen or had no reason to know that the perpetrator would behave in this way towards an individual, because and if it has happened and that individual has that freestanding harassment claim, whether it's harassment on the grounds of sex, harassment on the grounds of pregnancy or maternity, or whatever it is, the only way in which an employer gets off the hook for that harassment is if it's taken reasonable steps to prevent it. And employers, so it's not enough for an employer to say, well, I didn't know that they were going to do that. They have to have actually been proactive about it. They have to have policies, they have to have training, they have to have, and it's not enough just to have a written policy, yeah, they have to put that into practice and have training and things, and put in place measures to prevent these kind of behaviours occurring if they want to be able to successfully defend a claim. Now, I'm speaking about that from the perspective of here's how to defend a claim. Now, obviously, the primary aim is preventing it from happening at all, and training can be quite effective in that.
Yeah, and as you very well know, Andrew, in my workplace, Wellbeing consultancy, we help clients implement these what we call mental health and safety risk management systems, right? Which basically are it's a management system that has 4 components to it. Component number 1 is to actively identify hazards of a psychosocial nature. For instance, the bullying or the harassment or the role conflict or role ambiguity and workload, workplace, etc. Then second stage is to assess the severity, the frequency, and how many people are impacted, by these psychosocial hazards. Stage 3 is once you've identified those hazards and you've prioritized them, put control measures in place to make sure that you are either minimizing or actually eliminating these hazards. And 4 is the management review, which is basically spending time in a systematic way, reviewing those control measures that you've put in place and measure the effectiveness. Are they actually doing what they're supposed to do? Are they minimizing these hazards, or are they eliminating them? Again, a system that allows you to identify the psychosocial hazard, assess the level of frequency, severity, and impact, allows you to put the control measure in place, and then review it. Now, if an employer were to, go to the Employment Tribunal and say, listen, this has been a one-off. I mean, this is the first time that this particular employee has, behaved this way. But let me show you. We've got a policy, about, against harassment and against bullying, and we've got a mental health and safety management system in place that systematically allows us to identify behaviors of this nature. But this particular one kind of slipped through the radar because it was just a one-off. It was not systematic. What are the chances of the employer, not getting away sounds bad, but what are the chances of the employer against that particular claim if they can prove that, not only have they got the policies, but a mental health and safety risk management system in place?
Yes, no, it's quite interesting. And before I answer the question, there was a phrase that you used there, which was to do with minimizing or eliminating the hazard, and it's very similar to some of the language that's used in connection with an employer's duty to make reasonable adjustments for disabled people, which involves making adjustments to reduce the disadvantage that a disabled person suffers. So somebody with an underlying mental health condition, you have to have identified ways in which to try to reduce that disadvantage, even if you can't eliminate it entirely, to minimize it. But I just thought that was interesting that you used almost exactly the same phrase. But in terms of your question about what are the chances of an employer, and I will use the phrase getting off the hook. What are the chances of an employer getting off the hook if it has that kind of system in place? Well, it's certainly an extremely good starter for 10, because probably most employers that come along to the tribunal in that scenario where there has been harassment, they're trying to get off the hook. They point to a policy and they say, here's our policy. But the staff have never had any training on the policy. Or the staff have had training and it was a 15-minute talk about here's the policy. Or the training was 18 months ago. And quite often the claimant, the employee that's been affected by the behaviour, can point to lots of behaviours where managers knew they were happening, but didn't bother applying the policy because it was just banter, because it was just a joke. But coming back to the definition I mentioned at the beginning, it's just a joke isn't a defence, because the phrase in the definition is that the conduct was unwanted and had the purpose or effect of offending the individual. So if that individual is offended, then that individual's claim gets off the ground, and it's then really for the employer to start justifying its position. And if it has the kind of system in place that you've described, César, then that's the kind of thing, as an employer's lawyer, if you came to me and something happened, and you described this system and you showed me it actually being implemented in practice, then I'd be very pleased, and I'd start to be really quite confident that the employer has taken reasonable steps to prevent the conduct. You can never eliminate the hazard, to use your expression. You can never, in the context of human behaviour, you can never completely eliminate that, because humans behave as humans behave. But you can take reasonable steps to prevent it from happening, and that's the extent of the employer's obligation. So that's a very long way of saying I think they'd have a pretty good chance of successfully defending the claim.
Yeah, of getting off the hook. Actually, that I like of successfully defending the claim. That's the phrase that I was actually fishing for. Now, just to remind our listeners and our viewers that having a mental health and safety risk management system in place is not an optional thing. It's actually mandated by current legislation. And let me just read out loud for the viewers the Management of Health and Safety at Work Regulations of 1999. Specifically, I want to focus on Regulation 3, which is around risk assessments, and Regulation 5, which is about health and safety arrangements. And by health and safety arrangements, I'm talking about also psychosocial hazards. So Regulation 3 says that every employer shall make a suitable and sufficient assessment of the risks to the health and safety of his employees to which they are exposed and whilst they are at work, and the risks to the health and safety of persons not in his employment arising out of or in connection with the conduct by him of his undertaking. So Regulation 3, again, is about making sure that you have risk assessments in place, and these risk assessments should include, hazards of a psychosocial nature. And Regulation 5 is about the control measures that I was telling you about, in which in the language used in this particular piece of legislation is the arrangements. So Regulation 5, and let me read it out loud as well, is every employer shall make and give effect to such arrangements as are appropriate, having regard to the nature of his activities and the size of his undertaking, for the effective planning, organization, control, monitoring, and review of the preventive and protective measures. Where the employer employs 5 or more employees, he shall record the arrangements. So again, to our listeners and to our viewers, having a mental health and safety risk management system is not a nice to have. It's not a pretty add-on, to what you already have. It's actually mandated by current legislation, as stated, like I said, in the Management of Health and Safety at Work Regulations of 1999. And as you heard from Andrew as well, if you have to face a claim because someone at work decided to make a joke about a lady's symptoms of menopause, or make a reference to what do you call it, hot flashes, or or foggy brain, or anything like that, which might come across as banter or might be perceived as banter. If she's deeply offended and if she's deeply disturbed because she's just entering this menopause phase, and she's kind of in a very fragile psychological state, and a comment like that throws her into a deep state of distress, as Andrew was saying, she is going to have a valid claim to take to the Employment Tribunal. And if in the Employment Tribunal you cannot prove as an employer that you've had a mental health and safety risk management system in place, your chances are pretty low, to be able to defend that claim. Would you agree with it? Would you agree with me, Andrew, in that respect?
Well, I'd go further, in fact, because the claim that you described, you described the female as pursuing the claim. In fact, it can actually be somebody else in the room, somebody else that's overheard it, because it's all about the environment that's been created. You don't have to be the target. And it's not unusual for you to have situations where one person is having banter with another person, and they're both laughing and they're both finding it funny and they're both participating. But somebody over there isn't finding it funny and is quite reasonably finding it offensive. The claim can come from over there. And the claim can come from the person that the two people that were indulging in the banter, they didn't even know this person was over there, perhaps, and yet the claim comes from over there. So there's a very broad category of people that can pursue these claims, and I'll go one stage further. One of the things that we bring up when we are giving management training around preventing harassment in the workplace, one of the things that we bring up is to remind staff, to remind managers and colleagues and things that an individual can be personally liable. So the victim of the harassment will naturally go to the employer, who will typically have deeper pockets. But if they're well advised, then they will also go after the manager or after the perpetrator and have them as an additional party to the claim. So these claims are they're not to be thought of lightly. They're not to be dismissed lightly. They are they're growing in number. They are significant. They're not too difficult for an individual to pursue, and that's why it is so important that employers are well prepared to show that they have taken reasonable steps.
Now, in a previous conversation, that we've had, you mentioned something really interesting as well, that someone on the receiving end of the harassment, might not even be, or might not even belong to a protected characteristic group. And you gave me the example, and by the way, we were not joking about this, when Andrew and I were speaking about this. So what I'm going to say is not a joke, it's basically something that could actually happen in a work environment. Let's say that Jack says to Tom, "Hey, Tom, you're so gay because, you've gone to boarding school and you lived in Brighton," right? And Tom is not gay. He's not lived in Brighton. He's not gone. Well, actually, yeah. Let's say that he lived in Brighton and he went to boarding school, but he's not gay, right? So he's not under that, protected characteristic of sexual orientation. But that claim can still be brought under the Equality Act of 2010. Correct? Correct me if I'm wrong, Andrew.
Yes, that's right. And that example that you gave, César, that's a real case. That's an actual case where an individual had gone to, I forget if it was boarding school or private school or whatever it was, and that they'd lived in Brighton, and so their colleagues were thinking that it was funny to suggest that they were gay, even though the colleagues knew they were not gay. And but that individual was still able to pursue a claim. One of the things that's said to me sometimes is they don't have any protected characteristics. But that's not true of anyone. Everyone has protected characteristics. Everyone has an age, for example. So if you're treated less favourably because you are young, or because you are old, or because you are middle-aged, you have a claim. And equally protected characteristics, this isn't only about protecting minority groups. If, as an employer, you decide that you are going to pick on white males, and you're going to treat white males less favourably, then that white male has a claim. So, so it comes back to this point that I made earlier about the category of claimants is huge. Well, it's everyone, the category of potential claimants, and so yes. Another example is that you can pursue a claim if your employer has treated you badly because of somebody you associate with. So an example of a claim like that was a mother of a disabled child who was dismissed by an employer because they considered that she would need more time off and things like that. And she was able to bring a claim under the Equality Act. She herself was not disabled, but she was able to pursue a disability discrimination claim.
Oh, wow. Now, let's say that, and for employers listening to us, some employers might be saying, well, actually, they're not going to have the nerve to take the case to an employment tribunal because it's expensive. They're going to have to pay, up to £250 to raise the claim and £950 for the hearing, and they're not going to go through all that trouble, right? Now, I understand, and correct me if I'm wrong, that starting January of this year, the Employment Tribunal has decided to lower the fees for someone to raise a claim.
Okay. No, that's not quite right. For many years, pursuing an employment tribunal claim was free of charge. Then in 2013, tribunal fees were introduced, but there was court cases and things that basically eventually declared the tribunal fees to be unlawful. And so since, I think, 2017, don't quote me on the exact date, but around 2017, there have been no tribunal fees at all. And so an individual can pursue a claim without going to tribunal. Now, there is consultation around potentially introducing tribunal fees once again, but they are going to be of the order of £50. So if and when those fees come in, they're unlikely to be a barrier to many claimants. In addition, under the previous regime, if you couldn't afford to pay the fees, you could complete a form and then potentially not have to pay the fee anyway. There are also other ways in which fees can be paid. Crowdfunding is not as unusual as it used to be for certain types of claims, particularly harassment claims, religion or belief claims, these kind of claims. If an employer is thinking that it's going to be safe because an individual will be worried about money before pursuing the claim, then it would be a foolish employer. The individual only has to do some Googling. They get in touch with ACAS, who can offer them some guidance. ACAS being the government-funded body that I mentioned earlier. ACAS will offer them guidance and direct them to the appropriate forms and things. They don't need a lawyer to pursue an employment tribunal claim. The tribunal system is actually geared up in such a way that if you are an individual who doesn't have a lawyer and is pursuing a claim, there are ways in which the tribunal can essentially assist you to manage that process, so that you are not disadvantaged. So yeah, like I say, if an employer is thinking that it'll be on safe ground because an employee isn't going to pursue a claim because of money, then yeah, that employer is just making a very dangerous and misplaced assumption.
Yeah, and Andrew, recently I came across a case that happened a while back, actually. A lady basically raised a claim because, again, her employer breached its duty of care toward her, and she actually was working at a surgery, and she went through the whole, tribunal process, without a lawyer, and she was awarded £290,000. We're not talking about a big pharmaceutical company or a big, oil and gas company. We're talking about a surgery, and she was awarded £290,000. And I've just recently learned that amount was adjusted, and they increased it by £20,000 because they didn't take into account bonuses and stuff like that. Are those sizable awards pretty common, pretty rare when it comes to cases of breaches in duty of care?
Awards of that size are rare, but perhaps becoming less rare. Now, but it doesn't, as you say, it doesn't have to be an individual who is earning huge sums of money from a huge organisation to get those awards of that nature. So I act for employers, mainly for employers, but occasionally for employees as well. And I remember a number of years ago acting for a member of administration staff. This individual wanted to come back part-time from maternity leave, wasn't allowed to come back part-time, and was treated generally quite badly by the employer, and reacted in such a way, it affected her so much that she just couldn't come back at all, and she left, and her total award. So we won the claim. We pursued a claim, including claims of harassment and things like that, and other breaches of legislation. And the award that she got was nearly £100,000. We didn't quite manage to get over the £100,000, but it was a sizable award for somebody who wasn't a highly paid member of staff and was working as part of their administration team. So the awards can be sizable. They are uncapped. There's no cap on what a tribunal can award in a discrimination claim, there are certainly examples of individuals getting awards into 7 figures, depending upon their particular circumstances. When you so I'm talking there about tribunal awards. In the civil courts, where you've got personal injuries, if an individual suffers a breakdown and they're never going to work again as a result of that breakdown, then 6-figure awards in the civil courts are not unusual.
So, just to kind of summarize the employment tribunal experience, right? So basically, you're saying that, and thank you for the clarification on the fees. So basically, if an employee feels that their employer has breached its duty of care for a one-off, piece of banter, like we've been talking about, right? This person can actually go to raise a claim with the employment tribunal without having to pay anything. There's a scenario in which they don't have to pay anything, and even if they lose the case, they're not responsible for the legal fees of the employer, right? So virtually no barrier of entry. They get assistance from the government agency, ACAS, which is an advisory, conciliation, and arbitration services body. So they get assisted throughout the process, to make sure that, they're doing everything, filling out the right forms and everything else. And they can be on the winning side of a figure or six-figure reward just because someone said something inappropriate in a meeting. Just does that summarize kind of the level of exposure that employers have in the UK, primarily?
Yeah, absolutely. That's it. That's it in a nutshell. You mentioned there about the employer's legal fees. Let's take the scenario that they lose, that they don't manage to win the claim. Well, the employer has still effectively lost anyway, because the employer, there's been all the management time implications of having to defend these claims. There's been the reputational impact, because these claims appear on the internet. So even if you win a claim as an employer, you don't really want your name out there as having been the recipient of a tribunal claim alleging harassment and whatever. And if the employer has instructed lawyers in order to boost its chance of successfully defending the claim, then the employer has to pay those legal costs, even if the employer wins. As soon as a claim is lodged, then win or lose the claim, as an employer, you've already lost.
Yeah, it's very important what you've mentioned about reputational damage. So it's not just the financial risk, obviously the legal, risk. It's the loss of productivity, as you were saying, because some of these cases can go on for a year, 2 years, right? And you have to deal with that, right? And you have to deal with those distractions. But the reputational damage, so for instance, I mean, nowadays, in order for businesses to thrive, they need to make sure that they attract the best talent, right? And the most attractive talent they can actually find in that respect. And if I were to be someone, considered high talent, or, really good talent, I'm going to have choices, because really bright talent actually have choices, and they're going to have offer A, offer B, and offer C. And nowadays, with social media, with Glassdoor, I mean, there's so many different sites that you can actually just Google that particular employer. And if I'm considering my options and if I Google the name of this employer and I see that Google basically indexes, what you're saying about the Employment Tribunal reporting all of its cases, it's like, what? The employer that's trying to hire me, it's being sued because they breached their duty of care toward their people. I'm not going to work there. It's like, why would I expose myself to that kind of environment, right? So reputational damage, goodness me. Okay, Andrew. So let's be practical now, right? So I do want to give advice to both employees and employers, right? So let's start with employers. So employers, if you want to take a proactive approach to making sure that you are not exposed to situations in which employees will sue you because you breached your duty of care, it is imperative that, among other bits and pieces, you have a mental health and safety risk management system in place. Your traditional health and safety management system will not be enough. You need to incorporate the dozens and dozens and dozens of psychosocial hazards that we spoke about. And the best way to do this is by getting certified in an international standard like ISO 45003, which will force you to actually have this mental health and safety management system in place in order for you to identify, assess, control, and manage hazards of a psychosocial nature. That's absolutely essential. So that will prevent you from getting into these situations in the first place, or minimize the instance that this could actually happen. And in case something happens, having a system like this in place will raise your chances of defending your claim successfully. Now, in my business, that's what we do. How can Anderson Stathern help because obviously you just do not get involved in the litigation aspect. You can actually get involved in the preventative aspect as well. So what can you do for employers to train them and to help them raise awareness about, everything that we've been talking about, Andrew?
Yes, okay. Thank you, Cesar. You're absolutely right. It's not just when it gets to court or tribunal that we become involved. At Anderson Stathern, we are what we call a full service law firm. So we cover every aspect of law that an employer or an employee might need at any point. But in my own department, one of the things we do a lot for employers is we do training. And we go out to workplaces and we tell them about the law, but we tell them about it in a very practical sense. And we talk through different scenarios that we've dealt with, and to really hammer home to managers what their obligations are as managers, and to help the employer ensure that it's taking these reasonable steps. And much like you described, Cesar, one of the there's all sorts of benefits to that. There's obviously the hope of prevention, but there's also if prevention doesn't happen, if an incident still occurs, you can show that you've taken reasonable steps to prevent it because you have in place training. I mentioned earlier, there's not enough just to have a policy. Tribunals are very well accustomed to seeing employers that have policies and do nothing with them. So you need to have the policy, yes, but you need to train staff on the policy and why the policy is important and things. But you also need to react when the policy is breached. And that's another area that we help employers with. So it's not at all unusual for us to get a phone call from a client telling us something has just happened in the canteen, or something has just happened, an email has been sent, we've had this complaint, this grievance lodged, and then we get involved at that stage. We're not just a law firm. We also have a CIPD qualified HR professionals who can come out to the workplace and investigate these allegations, or help managers investigate and help on the ground when these kind of things happen. So we take things right through from the prevention in the form of the policy and the training, through the situations when things actually arise, and how you address those through grievances, disciplinaries, that kind of thing. And then, if necessary, when a claim is lodged, we defend the claim, and we rely upon all the other stuff that we've already done to defend the claim. Now, of course, sometimes we get employers who haven't done all that other stuff and haven't involved us, and then just say to us, by the way, I've got a claim, do what you can. And of course, we do what we can in defending that claim, but they are in a far better position if they've consulted with us first of all and got all their ducks in a row.
Fantastic. And now let's talk about the employees, right? So at least that's my advice, and I don't know if you would agree with this, Andrew, and you have the total right not to agree with me when it comes to this advice. If an employee, if you believe that your employer has breached its duty of care toward you because you've been on the receiving end, or you've experienced some kind of psychological harm because of a particular psychosocial hazard that hasn't been managed well. Again, workload, work pace, work hours, remote working in isolation, bullying, victimization, harassment, etc., etc., etc. My advice is at least give your employer a chance. Don't go directly to the tribunal, and just because what we want at the end of the day is for the behavior to stop. At the end of the day, that's what we want, and we don't want to lose our place of employment, and we don't want to make the situation too distressing and traumatic. Having to leave an employer, right? So, my advice would be, as soon as you notice this behavior happening to you or happening to someone else, write an email to that particular person asking for that behavior to stop, but in a constructive kind of way, and just and it has to be done in writing, because obviously you need to start creating, a paper trail, so to speak, in case the situation escalates. So you immediately communicate in writing to this particular person, saying, in the spirit of creating an environment in which everyone can thrive, I would like for you to desist from saying these things, doing these things, acting, this way, etc., etc., etc. If the behavior doesn't stop, then perhaps you can escalate that to HR in writing as well. If the behavior doesn't stop, you can escalate that to higher levels of management. And then if the situation doesn't stop, obviously, or the behavior doesn't stop, then obviously now I think it would be a good time to start thinking about taking some kind of action, like, going to the Employment Tribunal. Just to give you a stat, for all the listeners and viewers, at least in the UK, 77% of women have experienced a discrimination in the workplace. 77%, and only 1% have taken some kind of action, right? And the majority of these women that have been discriminated against, they actually feel that it's their problem, that it's them, there's something wrong with them, and they don't even think that it could be the employer's responsibility for creating an environment of that nature. So again, try to initially make the behavior stop. Again, communicating this in writing in a constructive kind of way. And then if it doesn't stop, then you can perhaps take the steps that Andrew and I have been talking about. Now, Andrew, what would be your advice? I mean, that's the way I see it, and I could be right or wrong, but it's just the way I see it. What kind of advice would you give employees that have been on the receiving end of a breach in the employer's duty of care?
Yes, so you said there that I'm perfectly entitled to disagree. As lawyers, we like to disagree. There's nothing like more than a good debate about things. But on this occasion, I would entirely agree that it's never a clever thing to do to resign unnecessarily and leave yourself out of work, even if you do have a good claim, because all you're going to get back, really, well, that's not quite, you can, there are all sorts of different awards you can get, but the reality is you're then out of work, you don't have an income, and that's not a good place to be. Whereas if you can stop the behaviour, then that's all good. And in fact, you are obliged to, first of all, take informal steps to informally resolve matters. Now, of course, there will be situations where the conduct is so horrific and so unacceptable that you will immediately want to make that formal. But if there is something where you think that an individual was perhaps well-meaning, and you are the recipient of the behaviour, then you might think, well, this is a circumstance in which I should give them a chance. This is a circumstance in which this might be able to be nipped in the bud and stopped. So yes, I would definitely advise taking those steps. And you mentioned, César, about leaving employment. Bearing in mind that even if you don't manage to nip it in the bud, you don't manage to stop it informally, before you leave employment, you can you can then lodge it formally with HR, and hopefully that works. You could even bring, if it's a harassment claim under the Equality Act, you don't need to resign to pursue that claim. You can lodge a tribunal claim. If nothing else works, if nothing else has worked, you can lodge a tribunal claim without resigning. So you don't need to lose your income, but you can still get your day in court if you like.
Oh, wow. Andrew, I could stay here talking to you for hours, but of course we need to be respectful of your time. Before we leave, Andrew, I'm going to put you on the spot here for a second. We usually ask our guests a couple of questions. The first question being, can you think of one or two heroes that you have, past or present?
Oh wow, this is terrible. Do you know, it's times like this that I really wish that I was a fan of football or rugby or some kind of sport, because then I could just name a couple of famous footballers, rugby players, or whatever. But I'm not, so I can't name any
So
heroes.
let me help you out. Think of someone who has inspired you or has influenced you or has, made you, make a decision that's been relevant in your life, whether it's family, friends, political figures, artists, people from the past that have inspired you just to take some course of action that has impacted your life in a positive way. Let's just put it that way.
Okay. Well, this is going to sound terribly cheesy, but my two children, my two daughters, they inspire me to go to work and earn a living and all that kind of stuff. You said that you mentioned about impacting my life. They certainly impact my life for a long time. Impacted my ability to sleep. And that still happens from time to time. My eldest daughter's soon to be a teenager, and she's definitely practicing to be a teenager. And that gives me cause for loss of sleep once again. So I'm going to opt out and say something cheesy, and I'll say that my two daughters are my heroes. My apologies that it was no better than that.
Actually, it's not cheesy at all, but I am going to ask you, what are the qualities, in your daughters that make you feel that way?
Okay. Their qualities.
Characteristics, qualities,
yes,
behaviors.
I suppose they have an ability to. I was going to use the word manipulate. I've been thinking. I've got that word in my head, and I'm trying to think of a nicer way of putting it. I suppose influence would be the nicer word, but that's just kind of a circular way of saying the same thing. I suppose their ability to sit there, say nothing, and still make you feel guilty, still make you feel that you have not done enough, you've not done a good enough job, and sometimes they make you feel that way much more effectively than when they're shouting at you and telling you all the different ways in which you've done a bad job. I don't know if that's what you were looking for, but that's all I could come up with.
All right, and one last thing. This will be a little easier, Andrew. Please complete the following sentence. This world would be a better place if
there was no requirement for lawyers.
Good one. Good one. I really like that answer as well, because as I say myself, I wish that my workplace well-being consultancy would disappear from the face of this earth, because that would mean that employers are fully complying with their legal duty of care and beyond that, right? So I really like your answer because it's very similar to how I, feel as well. So, Andrew, my friend, again, this has been really, really enlightening. I think a lot of people are going to get a lot of value from this, both employers and employees as well. And hopefully, this conversation will help to reduce, the level of work-related stress, anxiety, and depression that unfortunately keeps on the rise. So thank you for your time. Thank you for your experience, for your knowledge, for your wisdom. And hopefully in the future, we can have a part 2 of this conversation, right?
Yep. Thank you very much for inviting me on. Okay.
Yeah. And to all our listeners, if you like this podcast, make sure you click on the like button. And of course, if you want to be the first to benefit from the wisdom, knowledge, and experience of distinguished guests like Andrew, make sure that you click the subscribe button as well. All right. So thank you so much. And I'll be seeing you soon. Take care.